The law is closing in on Trump. There are now 3 clear indicators that criminal probes of Donald Trump are rapidly reaching a conclusion. First, in Georgia, a special grand jury investigating his efforts to overturn the presidential election in the state has concluded its work. The Fulton County District Attorney, Fani Willis, has indicated that charging decisions are imminent. Key parts of the grand jury report will be released this Thursday. Second, the Manhattan District Attorney's Office is reportedly presenting evidence to a grand jury regarding the accusation that Trump paid hush money to the porn actress Stormy Daniels before the 2016 election. Third, as the Times reported last week, the special counsel Jack Smith issued a subpoena to Mike Pence. The special counsel said it is investigating Trump's mishandling of classified information and efforts to interfere with the certification of the 2020 presidential election on January 6, 2021, and with the lawful transfer of power after the election. Pence is a direct witness to key events surrounding at least 2 of those subjects, January 6 and the election interference efforts before January 6. Pence is reportedly planning to challenge the subpoena on separation of powers grounds, claiming that his former role as president of the Senate was legislative and therefore entitles him to at least some protection from the Department of Justice's subpoena. But even if he mounts that challenge, issuing a subpoena to a former vice president is a significant step and not one likely to be taken for general information gathering purposes. Instead, as the former federal prosecutor Andrew McCarthy wrote in National Review, the subpoena indicated that a final charging decision was probably nearing and the prosecutor was preparing to cross the Rubicon. If prosecution decisions are imminent, what principles should guide the prosecutors? What factors should they consider when deciding whether to charge a former president? When weighing the facts and the law, they should remember the rule of law and apply the rule of lenity. They should not, however, consider politics or the potential of mob violence. In short, the guiding prosecuting principle should rest in the old maxim, let justice be done, though the heavens fall. The rule of law is easy to explain. America's Republican form of government does not create or permit a special class of citizens who are immune from legal accountability. The arguable exception is the serving president. It's the long-standing position of the Department of Justice that indicting a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions. But Trump, of course, is no longer president. The United States has prosecuted a vice president, governors, members of Congress and federal judges. The Supreme Court has held that presidents are subject to the legal process, even when they occupy the Oval Office. So yes, former presidents should be subject to prosecution. This position doesn't endanger our system of government, it protects and applies a fundamental American legal principle: we are all equal in the eyes of the law. But that principle of equality brings me to the second factor to consider, the rule of lenity. It's a principle of statutory construction that states, when a law is unclear or ambiguous, the court should apply it in the way that is most favorable to the defendant. Another way of stating the rule is that the government shouldn't stretch or extend the law to criminalize misconduct. The rule of lenity is both just and practical as a matter of justice. Should our nation be prosecuting citizens criminally under novel legal theories? The law should give fair notice of its scope, and it should be clear enough to permit us to conform our conduct to the relevant legal standards. Expanding the reach of laws beyond their plain text violates this principle and undermines trust in law enforcement. Applying the rule of lenity to Trump, as it should be applied to every citizen, means that he should be prosecuted only when the evidence indicates that he has clearly violated laws with plain and clear meaning, either on their face or as further defined by controlling precedent. In addition, we know that Willis has stated that 16 Republicans who falsely claim to be Georgia's valid presidential electors are targets of her criminal investigation. The fake electors scheme and the threats directed at Raffensperger clearly implicate the plain language of the relevant statutes. As Ian Bassin and Erica Newland argued in a powerful and persuasive New York Review of Books article last July, it is beyond the proper powers of the Department of Justice to weigh whether indicting would be in the national interest. Weighing the national interest is the president's purview, and the path to avoiding prosecution for the sake of national stability is through a presidential pardon, not through an exercise of prosecutorial discretion. Presidents can pardon federal crimes. They cannot pardon state crimes. But even if President Biden could pardon Trump, he should not. If the evidence clearly indicates that Trump committed a crime, he should face a jury, and if the jury convicts, he should go to prison. After the Senate failed to convict Trump in his impeachment trial, the criminal justice system is one of the last lines of defense against this malignant man and his malignant mob.